Hi, everyone. Good afternoon. We finally got through with the fire drill, so we can begin. Thank you for joining the Transformative Practices Promoting Access to Expungement webinar. My name is Chidi Umez, and I am a project manager for the Criminal Records Project with the Council of State Governments Justice Center. The Council of State Governments Justice Center provides practical, nonpartisan, research-driven strategies and tools to increase public safety and strengthen communities. Before we get started, I'd like to just go through a couple of housekeeping items about how the webinar is going to work. So anytime during the webinar, you can ask a question by typing it into the Q&A panel there on the bottom right-hand portion of your screen where it says Q&A. This includes both technical and content-related questions. We will try to reply to technical questions in the chat window as we go. For the content-related questions, we will keep a running list and address them all at the end of the webinar. We'll do our best to go through as many questions as we possibly can. If you do encounter technical or audio problems during this webinar, please call WebEx Technical Support at 1-866-229-3239, 1-866-229-3239. Please understand that there are some technical issues that we may not be able to resolve, and for that reason, we're recording the content portion of this webinar and we'll post it to our website at cleanslateclearinghouse.org. And we should be able to post that online in the coming weeks. Our presenters for today are Jamie Gullen, the Supervising Attorney with Community Legal Services of Philadelphia, Beth Johnson, Director of Legal Programs for Cabrini Green Legal Aid in Chicago, and Alex Kornya, Assistant Litigation Director for Iowa Legal Aid. This webinar is a part of the Clean Slate Clearinghouse, a project funded by U.S. Department of Labor and U.S. Department of Justice. The Clean Slate Clearinghouse was created to support juvenile and adult criminal record clearance around the country by providing up-to-date information on record clearance, as well as contact information for legal service providers in all U.S. states and territories. The Clean Slate Clearinghouse was developed to provide tools and resources for legal service providers currently engaged in record clearance work, or those who want to expand their record clearance services, and it provides information to compare record clearance policies across jurisdictions and to learn about best practices. The site was designed to capture 3 target audience groups: people with criminal records who are seeking to have their record cleared, legal service providers who offer record clearance services, and policymakers who want to compare record clearance policies across the country, with the primary goals of providing accessible, up-to-date information for record clearance policies across the country and increasing the capacity of legal service providers while creating a community of practice around record clearance. Within those groups, however, we also anticipate that the site will be used by reentry and workforce service providers who can connect people to services, by indigent defense attorneys or pro bono attorneys who are interested in starting or expanding their record clearance practices, and researchers or journalists who want to compare trends in record clearance legislation across the country. And with that, I will hand it over to our first speaker, Jamie.
Hi, everyone. Thanks for being with us today. I just wanted to start by giving a little bit of context about why we pulled this webinar together and why we think it will hopefully be useful before I turn it over to my colleagues to start digging in. So to start, why expungements or why record clearing practices? As you may know, 1 in 3 Americans has some kind of criminal or juvenile record, and half of all children in the U.S. have a parent who has some kind of record. So that's a huge scope of people who are in need of record clearing services. And while record clearing certainly isn't the only tool to combat issues around discrimination against people with records in housing, employment, education, and more, we have found in our office that clearing a record when a record can be cleared is one of the most effective ways to help people overcome barriers that they're facing because of those records. There hasn't been a ton of research done in this area, although there's more in the pipeline now. But some of the research that has been done on studying the impact of record clearing has found an increase in income for people who've had records cleared, as well as an increase in confidence of people who are going out into the job market once they have their records cleared. So in addition to, I'm sure, the anecdotal experiences that we all have in seeing the life-changing impact that clearing up a criminal record can have, there's a growing body of research that suggests that it really does have a lot of benefits for people who go through that process. So with that context set, we have 3 different programs we're going to be presenting today about innovative work that they do to increase access to justice for people with records, because the scope of the problem is so large that traditional legal aid methods of intake are not always sufficient to really reach people who are most in need of services. So we're going to hear about different approaches organizations take to making sure that people are able to access their services. So we're going to hear from Cabrini Green Legal Aid, Iowa Legal Aid, and Community Legal Services of Philadelphia. And with that, I turn it over to my colleague Beth Johnson from Cabrini Green Legal Aid.
Well, hello, everyone. Thank you for setting the stage for us, Jamie, and what we're going to be presenting on today. So the next portion of this is going to be talking about the work we're doing at CGLA here in Chicago. Some of you may know us or heard of the work that we've done. My goal is to provide an overview of the organization briefly, but particularly focusing on the work we do in our criminal records program as ways to mitigate or remove barriers to employment, housing, licensure, and all other life needs that folks have when they come to see us. And so for a little bit of context, we were founded in 1973 to serve one community, the Cabrini Green community, which was a public housing project here in Chicago. And it was founded as a way to address the legal needs that arose in one community due to concentrated poverty, targeted criminalization, and the impacts that that had on folks. But with the change in public housing, both in our city and many others, we moved from site-based public housing to a system of Section 8 vouchers where we didn't have needs in one community, but the needs that we were founded to address didn't change. We still have the criminal system that's impacting folks, particularly those that are living in low-income and communities of color. We've always been unique for one reason, and that's because of our work in the criminal space. Now, back in 1973, while there is an expungement law in the books, it is a completely different legal world in Illinois since then. But our growing practice of work in criminal records led us to launch our most recent strategic plan that focuses us on ways to strengthen lives, families, and communities negatively impacted by arrest and conviction. So these are the 4 principles that guide the work that we do in the present. The first is that we're focused. All of our legal services are targeted for people impacted by the criminal justice system. So for criminal defense work, that makes absolute sense, right? Our criminal records work, that makes sense. But even our civil legal services are now geared toward that focus as well. For example, our housing work is 100% focused around people that are threatened to lose their housing or not be admitted to housing because of an arrest or conviction of themselves or a family member or a guest. Our family law practices focus on people that are incarcerated that can't access the civil legal system. We have an asset forfeiture defense project. Again, all those civil legal needs that come out of an arrest or conviction. Our services are holistic in the sense that we do have social workers on staff that are part of our in-house cases as members of the legal team. As any lawyer on this call knows, we are not the things that save somebody's day. We are one part of a bigger puzzle, and we can expunge or seal records all day long, but if individuals don't have supports outside of that, our work is for naught. And so that is our way to address not just the legal need that walks in the door. Our work is collaborative in the fact that we recognize working in partnerships results in greater outcomes. As a legal aid, we are never going to replicate the services of some of the awesome workforce development agencies or homeless service agencies or violence prevention agencies. That's their forte, just like they wouldn't replicate what we're doing as lawyers here. Together, working around the same population of folks, we're strengthening our outcomes and staying in the areas in which we are experts. And finally, it's transformative. We work to change the underlying systems that result in the need for our legal services. There's no point in encountering the same barriers over and over and not actually working to address those underlying laws that result in that legal need. And so that rounds out the focus of our work here at CGLA in the present. So with that work, this is just our numbers from FY17. We're on the July 1st fiscal year, so closing out our last fiscal year. We're serving a little over 6,300 folks each year. The legal services delivered are higher than that only because we have clients that have multiple legal cases that we are involved with. But as you can see, 84% of our legal services were in our criminal records program, which is our biggest program. So the first three big portions of the pie, the help desk summits and the in-house records work, is what I'm going to focus on for my remaining minutes here. So in the records program in FY17, that's just some of our numbers. And where do our clients actually come from? As you can see, the vast majority of our work happens through our help desks. We have an in-house practice as well, the litigation for folks that can't be assisted through just expungement and sealing. And summits, the one on the far right, that's like a help desk that's mobile and picks up and drops into different communities and clinics to be able to provide services outside of Cook County where we live, because despite what we might think in Chicago, Illinois has more than Cook County to it. There's 102 counties in Illinois and the need to address those legal needs. So I was going to go through each one of these now. So inside in our internal program with our direct services, every state's different. We all know that. So expungement and sealing are petitions through the courts for both arrest and non-conviction as well as conviction records. What the program does are the alternative forms of relief from a criminal record. Those include things like certificates of good conduct, clemency petitions from the governor, healthcare waivers, industry-specific waivers that individuals might need, Human Rights Act claims in Illinois, as well as doing community education and mobilization. So that's what our practice focuses on, and how we do that will be discussed through here, because clients are coming through four main sources to us: through our help desks, through our summits, through the community overall. They just know to call us to receive services, as well as our partnerships. So looking at our help desks, for those that don't know, these are partnerships with the clerk's offices in our county. We have shops set up within the clerk's offices where people have to file petitions to expunge or seal. We're right there alongside the clerks, often mistaken for the clerks, where folks come to us, they come in with their records, and they're trying to get assistance in filing a petition to expunge and seal. So these are just the different locations. As you can see, our primary, the biggest numbers come from our Daily Center help desk that we launched in 2005, and that's the main central courthouse down here in Chicago. Markham is one of the south suburban courthouses. The juvenile help desk is the juvenile court here in Chicago. And the 26th Street court call, which you wouldn't know if you weren't here, is for individuals that have objections filed by the state. We provide representation to pro se petitioners facing an objection by the state's attorneys. And so, again, this requires partnership with the clerks. It's operated by one staff and anywhere from 3 to 4 volunteers each day. Each placement of the help desks has different numbers of shifts we have each week, but there's about 8 shifts that we're covering both internally and through volunteers every week that these total numbers come from. The community summit model, like I mentioned a little earlier, is like a help desk, but you're picking up your operations and dropping in a local jurisdiction. So what is a community summit? It's partnering with some stakeholder or community organization in a jurisdiction, and particularly focusing on areas of need in terms of not having legal services available. Now, in Illinois, outside of Cook County, there are two major legal aids, our LSC-funded organizations. And while our partnership and work has increased over the last couple of years, prior to that, those organizations didn't have the capacity to do that work. And so what we would do is go in to provide trainings for those legal aids as well as a local bar. And over 1 year, a little over 1,000 people came through these summits. The one in Cook County, and the purple is obviously the biggest. We've been doing that for the last 12 years with the clerk of the circuit court. And Peoria and Champaign County are two other counties here in Illinois. Individuals register in advance. We train and deploy volunteers. Over 250 volunteers participated in these summits over the last year. But not only are we coming in to do a summit, but we're building local capacity. So you have a group of pro bono attorneys that are remaining to work with the local legal aid. You have a local legal aid that's also enhanced to continue providing the services for folks. And then we visit each year more and more requests to do these throughout the state. In terms of our in-house cases, while a lot of our work does come through help desks as well as the summits, partnerships have been the way in which we are able to reach our clients for our in-house practice. We have two types of partnerships, collaborative partners and referral partners. We have some bullet points about the basic differences, but what's the thing we have in common with our partners is that whoever is participating in their program has some form of a barrier due to a criminal record and they need legal services. So it encompasses both screening records, providing legal services, training both participants in the program as well as staff members of the program, all in a collective impact-like goal to have the strongest outcomes at the end of the day. And in FY17, these are just some of the numbers and places that folks were coming from for our partners. Our partners directly refer through our case management system. They create profiles. We use Legal Server at CGLA, and we're able to provide the legal services needed for the folks that are referred. And I'm going to move through these just a little quicker now to pass over to my friends here. Lastly, in terms of the community education, we focus on not only doing Know Your Rights, but going into jails and prisons. In Illinois, we have an educational exception for someone to not have to wait 3 years to seal their conviction records, and so it's important that folks know that while they're serving their sentence and serving their parole upon release. One of the elements of our community presentations has been having members of our leadership council being the ones delivering that information and having an attorney on the side there for legal questions, but having that delivered through folks that have been there and walked that walk themselves. Again, I mentioned our different pro bono hours. Over 444 volunteers provided over 18,000 hours to us in FY17, and again, primarily through our criminal records program. And this is just some of the numbers in terms of law firms and corporations. We coordinate what are called ABCO clinics. Those are clinics for folks that can't expunge or seal their records but need certificates or waivers, engaging the local bar to provide that direct representation, as well as partnering with local law schools and corporations for our clemency work, both Allstate and Denton's, handling over half of our clemency petitions last fiscal year. I'm not sure where that line came from for opening the door for hundreds of felony convictions to be sealed, but it did that. Our most recent bill that we had signed in Illinois, prior to August 24th, only 9 felony convictions were eligible for sealing. Now, all convictions are eligible for sealing except some limited buckets of domestic, registration offenses for the sex offense registry, DUIs, and animal crimes, but there are no further distinctions between violent and nonviolent any longer in Illinois, which is fundamentally changing our practice. And so that is ending my presentation. I'm going to turn it over to my colleague, Alex, in Iowa.
Well, thanks a lot, Beth. That's really excellent work, and we're going to talk a little bit about Iowa Legal Aid's much, I guess, more recent foray into expungement clinics, expungement and employment barriers clinics. So my name is Alex Kornya. I'm the Assistant Litigation Director for Iowa Legal Aid. Iowa Legal Aid is an LSC-funded law firm, so like the LSC firms that Beth was referring to earlier, they're Land Lincoln, Prairie State, they're in Illinois, along with LAFC. We are a statewide LSC law firm. We cover all 99 counties in Iowa. We have been around for just over 40 years. Typically, the sorts of cases that we cover are about 30% family law, 30% housing law, mostly related to eviction defense, but also foreclosure defense, land contract installment issues, background check issues, things of that nature. But another 15% of what we do is related to consumer protection law, things like bankruptcy, debt collection defense, illegal repossessions, unfair collection practices, and things like that. And the other 35% of what we do is a whole host of other things that ranges from special education to our taxpayer clinic to elder law to public benefits, and now, increasingly, over the last, I would say, probably 8 or 9 years, civil collateral consequences of criminal justice involvement. Now, our expungement work has really taken off as an outgrowth of work that Iowa Legal Aid has been doing in the area of court debt, or collection of fines and fees related to criminal, juvenile, and civil proceedings. And so we've been doing a lot of work in that area. Unlike Illinois, it's really great to hear how Illinois expungement law is coming along. It's extremely important. I would say Iowa is light years behind the curve that Illinois seems to be on the crest of. So our expungement law is far more limited. And I would say even as recently as 2 or 3 years ago, there was almost nothing that could be done here in Iowa. And recently, we had some legislation open the door to start dealing with what we consider here to be sort of a root cause poverty issue. You know, Iowa Legal Aid, like any LSC law firm, we get in the door all the crises, all the evictions, the utility shutoffs, the things that have to be dealt with at that time. But like any good legal aid attorney, we don't just look for the technical defense to the eviction or how to deal with the utility shutoff or the foreclosure. We also look at the underlying issues to figure out what is it that's restricting income or keeping this person from being able to meet these financial needs, what is keeping them in poverty. And as everyone who's on this call, I'm sure, undoubtedly knows, criminal records issues are one of the major causes of poverty, just for keeping people unemployed or underemployed, keeping people away from, unable to access transportation, especially in a rural, mostly rural state like Iowa, where you don't have any kind of public transportation system to speak of, and definitely reduces, if not eliminates, housing and employment options. So our expungement and employment barriers clinics was our attempt to, one other thing I'll say about the connection between court debt collection and expungement here in Iowa. For the most part, the major hitch or obstacle to getting an expungement in Iowa is going to be debt related. Most of the time, a full payment of whatever is owed is required to be paid before a case can be expunged. Now, one of the primary types of cases that can be expunged here in Iowa are cases where all charges have been dismissed or the person has been acquitted of all counts. You might think, how could debt be an obstacle in those sorts of cases? Well, it is not uncommon for people to owe hundreds, if not thousands of dollars for dismissed charges, specifically for what we call indigent defense reimbursement. It's essentially paying the state back for the cost of your defense. And that's a win or lose type of debt. So last year, or back in 2016, probably the beginning of 2016, so almost 2 years ago now, Iowa Legal Aid's Race Equity Committee, which is kind of an extra, a committee of lawyers from 7 of our 10 regional offices in Iowa who look at the ways that racial justice and poverty intersect, sort of on, again, a root cause level. One of the things that this committee came up with in 2016 was the idea to create expungement and employment barrier clinics, with the employment barrier portion of the title referring to issues such as court debt collection, licensure and denial of vehicle registration, and also private background check issues, professional licensure, and a whole host of other criminal justice involvement-related issues. The project actually focuses specifically on 4 cities in Iowa that have statistically significant disparities in poverty, unemployment, and incarceration rates for African Americans. Iowa has the dubious honor of being at or near the top of the list when it comes to per capita incarceration rates for African Americans over the last, I think, at least 5, if not 10 years. And the point of the clinics is to reduce barriers to self-sufficiency caused by criminal justice involvement. The funding that we received for this project actually came from a special IOLTA, or Interest on Lawyer Trust Accounts project. Most states have an IOLTA fund which collects interest on trust accounts held by lawyers that keeps money that is involved in litigation. That interest goes into a fund which is administered by some sort of commission or organization. In Iowa, it's by a commission formed by our judicial branch. Other places, it's a separate nonprofit. And this money is distributed for legal aid purposes for the most part. However, over the last, I think a couple years ago, 2 or 3 years ago, there was a settlement between the U.S. Department of Justice and Bank of America related to foreclosure irregularities, and part of the settlement involved payouts to state IOLTA funds by Bank of America based on sort of a pro rata distribution of people in poverty, sort of the same formula that LSC uses to fund civil legal aid across the country. And it was for 2 possible purposes. One was foreclosure prevention, and the other was community redevelopment legal assistance, the latter term not being defined any further than just those 4 words. And so we were able to successfully make a pitch that community redevelopment legal assistance, in other words, helping neighborhoods, not just individuals, really one of the major issues in a lot of the areas that we were focusing on was an overrepresentation in the criminal justice system, and therefore an overrepresentation of the collateral consequences that are associated with that. And that was one of the things that was sort of economically depressing those neighborhoods. So we could get in, focus activity and focus services in those neighborhoods to try to ameliorate those collateral consequences, including record sealing, but also court debt work and licensure work, then that might be able to be something that would help turn those neighborhoods around. So this is an old slide. I prepared the slides for this a long time ago. So at this point, we have completed exactly 5 clinics throughout Iowa, in Des Moines, Davenport, Waterloo, and then beginning in February of next year, we'll be having our first clinic in the city of Dubuque, Iowa. We have another 10 clinics scheduled for the life of the project, which runs until mid-2019. The structure of the project is that we take expungement cases sort of as a normal matter of course through our general intake, along with all the other cases I described earlier, the family law, the housing law, the consumer protection law, but these clinics are focused on going specifically to these areas and getting through and talking to as many people as possible, and also going out into the community. So instead of having people come to us, we go to them. And we do a lot of the prep work before we get out there. Again, the clinic covers expungement, court debt-related issues, license and registration, and background checks. I already covered this. The workflow is essentially something like this. Iowa Legal Aid partners with a site hosting partner, and sometimes other agencies that will help with things like marketing. The idea is that these agencies provide space at a location in the community where people are already comfortable going to. It's not going to the lawyer's office, it's going to the local church or community center that they already might go to for lots of other purposes. The site hosting partner does the advertising and marketing for us, and also does the first line of vetting for cases. They send to us information that they gather for clients. We check them for eligibility. We do have income guidelines. that are tied to our LSC restrictions. I think future iterations of the project might possibly change that, although we haven't had too many issues because most of the people who apply are not over income from our purposes. But we check them for conflicts and other eligibility, and then once they are in our system, we have a set of law student volunteers currently at the University of Iowa, kind of a squad of folks who will actually analyze the criminal records. Iowa has an online criminal record system, which is good and bad. It's bad if you're the defendant. It's good if you're trying to do work and pull information, because a lot of information is available. Not only the charge information, but a lot of the information that is needed to analyze whether a case is expungible, and also a lot of information about court debt. I know this is not a court debt related webinar, but you know, one of the things, as I mentioned, that is the major obstacle to getting an expungement here is dealing with court debt, and the analysis of that sort of depends on figuring out what kinds of debt people owe for the most part. That's probably the simplest way of saying it. So people have more legal options and more recourse perhaps for things like the repayment of court-appointed attorney fees and defense fees versus something like a punitive fine versus something like victim restitution, et cetera. So law student volunteers will pull the information, the raw information from our Iowa Courts Online system and put them into something called the Criminal Records Spreadsheet, which I will show everyone here in just a moment. Once the, in fact, I'll go ahead and show that now. So I'm going to go ahead and share my screen. And we should be seeing the Criminal Records Spreadsheet here. So this is simply a programmed spreadsheet on Microsoft Excel, which we use to be able to get information and have a lot of the analysis done that we need to have done before the day of the clinic itself. So on the day of the clinic, the attorneys who are coming in have everything they need. You know, they ask a few more questions that can't be gleaned from the criminal records posted online, and then they, once those questions are asked, they're able to help people put together pro se expungements, advise people on what they need to do about court debt, and then flag cases that will be, where extended service by Iowa Legal Aid will be required. So just to kind of give you a little bit of a tour here, we have a basic tab here. This is something that has data points that will trigger automatic calculations later on in the spreadsheet. We have our case data page. This is the main data entry page. This is obviously a fake person. Prince Eric Fuller was the defendant actually in 1974's Fuller v. Oregon, which is one of my favorite United States Supreme Court cases about court-appointed attorney fees. Look it up. It's a great case. And so, as you can see here, we have things like case number, county, charge date. All of these things trigger, or most of these things trigger fields later on in these other tabs here under the expungement, bankruptcy, license and registration, exemptions, and statute of limitations tab. As you can see here as well, the court debt is all broken out by type of court debt, which also has programming implications for what happens later. So all of the rest of the spreadsheet after that particular portion fills itself in automatically. And so we can see here there's various types of expungement, juvenile, dismissal, acquittal, deferred. And for those cases where the parameters sort of show a check the boxes type of expungement, automatically these fields will show up as highlighted. And where there is a debt barrier in particular, or maybe some other kind of timing barrier, you'll see a box that lights up in red. So it kind of gives the attorney who is going to be talking with the client a quick at-a-glance look at what the person's entire profile is and is able to sort of counsel them accordingly. The same goes for bankruptcy. This is a lot of the bankruptcy, license registration, and exemptions tabs are based off of information and legal theories raised in the National Consumer Law Center's Confronting Criminal Justice Debt treatise, which is a very, very good, specifically the litigation guide. If you have not seen that and you're interested in this work, I would suggest Googling NCLC, Confronting Criminal Justice Debt, and it's free. It's a wealth of information about how consumer law and other related legal theories apply to court debt and, by extension, court debt blocked expungements. We also have a license and registration page. which sort of helps us analyze what kind of debt might be blocking a license, because some, but not all, debt blocks licenses in Iowa, and exemptions, and also statutes of limitations. So I'm going to stop sharing my screen now, which I think I did successfully. So going back to the workflow now, so on 4, we have volunteer attorneys who review those criminal record spreadsheets, and also what we call a preliminary assessment, which is kind of a summary page that goes in the front of it on the day of the clinic. They finish asking questions. I see a question here. I know we're supposed to get to those after, but I just wanted to get to this one now. It says, how do you get attorneys to provide pro bono? Other folks can talk about this, I'm sure, but for us, it is actually very easy to get attorneys to do pro bono work, because a lot of what we are normally trying to get attorneys to do here are things like divorces, are things like longer-term cases or wills cases. This is a type of case where it's kind of while we encourage them to take cases for sort of long-term representation after the day of the clinic, all we really ask them to do, all we require them to do, sort of in the first instance, is to be trained on how to do the work, and then show up the day of the clinic, give advice, and help with the pro se forms. It has been a very helpful thing, specifically in that expungement is new here, and court debt advocacy is not widely practiced by the private bar. It has given us the opportunity to educate attorneys from big firms, criminal defense attorneys, and other attorneys from other nonprofits, solo practitioners, rural folks, just a whole host of different types of people, and we're able to educate them, and they are able to go out and make these arguments for their own clients and help spread the word, and also expand people's rights beyond the cases that they help us with. The information flow works the other way, too. We've been able to uncover some debtors' prisons practice that my colleague Rob Poggenclass, who's sitting here in the room with me, who does most of the litigation on the cases that come out of the clinics for extended service, we'll talk about briefly. Some of the criminal defense folks in particular are able to give us information about localities that we wouldn't otherwise have as legal aid organizations. So once we have the client interview, we advise and help up with forms. The last step is wrap up and triage. So again, essentially Rob and I will come back to the office the day after a clinic or the Monday after a Saturday clinic, and we will go through each case and decide what we can do, what the best course of action is, and what we can do given resources. So we talked about the criminal record spreadsheet. We talked about, I think, most of this stuff already. Rob and or I also, on the day of the clinic, in order to make pro bono attorneys feel supported, and even some of our staff attorneys who feel supported, although most of the attorneys who do work at the clinics are pro bono, we kind of float around and we answer their questions. So we kind of make sure, usually pop our heads in between, I guess, 2 or potentially a lot more, depending on the attorney and the situation, times during the course of the client interview. And with that, I'm going to actually turn it over to Rob Poggenclass, who's a staff attorney here in our Des Moines office and our lead attorney on the Race Equity Project. And he's going to talk just very briefly about a couple of the good stories from our extended service cases, which I should add have really only arisen since June of this year when our project started. Rob?
Yeah, so most of the cases that I've been able to litigate have come out of the expungement and employment barriers clinics. As Alex mentioned, court debt is a big barrier for the new dismissal, acquittal, expungement law in Iowa, which requires that all fines and fees be paid before a charge can be expunged. With respect to court-appointed attorney fees, we have a solid equal protection argument that we've now made successfully twice in 2 different localities, arguing that someone should not be denied an expungement simply because they have not been able to pay back their court-appointed attorney fees. There's a case from 1972, U.S. Supreme Court, James versus Strange, which many of you are probably familiar with. We've made that argument twice now successfully, and I have at least 3 other cases in the pipeline making the same argument in different localities until there's an appellate decision on the matter. Another one I actually just argued this morning involves statute of limitations. So you noticed Alex has a statute of limitations tab on the criminal record spreadsheet. In Iowa, there's a 20-year statute of limitations on civil judgment debt. And so this morning, I was able to make the argument that in a case that has been pending, I think, since our very first clinic in June, that the statute of limitations had run on this court debt, and so I was able to get the court to discharge the entirety of the debt, most of which was court-appointed attorney fees. And then the third case actually came to us out of the Waterloo Clinic, where a private attorney who was volunteering let us know about some very predatory, I can say, practices going on in Waterloo, where the county attorney's office is holding people in contempt of court, or at least attempting to hold people in contempt of court for non-payment of some very, in the case that we have and in some other cases, non-payment of very old court debt that is, under Iowa law, treated as a civil judgment. So getting people in the door by threatening them with the possibility of jail time, and then once they come to court, getting them to enter into, and often, many cases, payments that they can't afford to make. And so we are trying to upset that practice as best we can in a case that's still pending.
And with that, I'll turn it over to Jamie.
Great. Thank you so much, Alex and Beth, both for your wonderful work and for presenting about it today. I will try to only add and not duplicate many of the wonderful points you've made. So I am an attorney in our employment unit at Community Legal Services in Philadelphia, and CLS has been working at the forefront of issues around advocating for people with records for nearly 2 decades, and our practice in our employment unit includes litigating Title VII cases, doing commercial background check companies, reports on the impact of records on our clients and communities, and more. So in our in-house intake and employment unit practice, we cover a wide range of issues. But in response to the growing need we saw from our clients for record clearing services, expungement has become the #1 way that we seek to help clients with their records. And like Iowa, we're nowhere near Illinois in terms of what can be expunged. When we talk about expungement in Pennsylvania, we're still mostly talking about arrest records that did not lead to conviction. But we've regularly found that even just arrest records are being held against our clients in employment, housing, education, and more. So expungement has really become sort of the bread and butter of our direct services for clients. And this is a chart we use to show how our intake has changed over time at CLS. So the tall red bars are overall intakes in our employment unit, and the blue bar are criminal record intakes. So you can see that back in 2000, we hardly had any criminal record intakes, and now criminal record intakes regularly account for about 2/3 of the cases our employment unit sees. And that's for a number of reasons. It's partially because of how available records have become thanks to technology, the growth of the commercial background check industry, as well as employers increasing their reliance on criminal background reports over time. So all of those factors combined have led to just a huge boom in the demand for record clearing services. So we knew we were seeing a lot of clients coming into our office through intake who needed expungement help. But we also started to wonder about what the data looks like in Philadelphia. We know Philadelphia, of the top 10 big cities, has the highest incarceration rate. We knew there were a lot of arrests happening in a lot of neighborhoods, and we were only touching sort of the tip of the iceberg of the need for our services. So along with my colleague, Michael Hollander, who some may know, who's a tech data guru, he was able to arrange for a bulk purchase of court data from the Pennsylvania Administrative Office for the court system, and we were able to basically get just a wide range of court information for the whole state. And using that court data, we were able to see neighborhoods that had more arrests versus neighborhoods that had fewer arrests, and then we could compare that with our own legal server database data about where clients are coming to us from and what neighborhoods. And by having those two different data sets, we could see how well we were meeting the needs of clients in neighborhoods that had the highest arrests. So by analyzing this data, I'm going to flip to this slide briefly. By analyzing this data, we're able to see, if you see the graph on the left upper side of your screen, that was the data we were able to get from the courts that shows total arrests in Philadelphia from 2010 to 2015. And the darker the color of the red is the more arrests you see in those neighborhoods. So you can see there are neighborhoods specifically in North Philadelphia and some in West Philadelphia that have very high levels of arrest compared to other areas like our downtown Center City area. And then if you look at the other chart on the lower right-hand corner of your screen, that was juxtaposing our intake data with those same arrest rate areas. So you can see in some neighborhoods, like in West Philadelphia, we were doing a pretty decent job of meeting the need based on arrest information in those areas. But in huge swaths of North Philadelphia, including a neighborhood where we actually have a neighborhood office, we were seeing far fewer clients coming in to seek our services, despite the fact that those neighborhoods had a very high level of need for those services. So by looking at this data, we realized that we needed to do more to really integrate ourselves into the communities where there were the most need for our services and work with community partners to make that happen. So in response to looking at this data, we launched our expungement clinic program right at the end of 2014. And we started out by pairing up with Temple Law School and law students who are working under the National Lawyers Guild umbrella. And they were able to organize themselves into a group that was interested in taking on this issue with us. So over the past few years, we went from having about 10 or 15 interested students to having over 70 students who are interested in volunteering with our program, which is pretty incredible. So over the last 2 full years that we've had our clinics program, we've held more than 20 large-scale expungement clinics across 12 different neighborhoods in Philadelphia, which has resulted in more expungements citywide and particularly in key neighborhoods. So now I'll show you our after data from looking at our 2 years, 2015 and 2016 of data. You can see that now in many areas of North Philadelphia, in your bottom right-hand corner graph, you can see in many areas of North Philadelphia we're doing a much better job than we were before in terms of meeting need, and we're just doing way more expungements overall. You can also see there are some areas where there's still a very high need. For example, the reddest neighborhood on your top left corner map, in 2016 we were still not doing a very good job of meeting the need in that community. And we addressed that issue by actually having a fellow, a new attorney, come into our office and develop a project where he is situated once a week at a social services agency called Congreso, where he is able to work with service providers to directly be on site providing record clearing assistance in that neighborhood. And our 2017 numbers, which will be complete soon, will show a huge increase in access to services from him being on site once a week in that neighborhood. So we have found by looking at this data that being a presence in a neighborhood, might sound very obvious, but having a regular presence in a neighborhood and working with trusted community partners has greatly increased the ability of people in those neighborhoods to access our services. So we were able to do this and really ramp up our expungement intake with not really much of an increase on any paid CLS staff. The only person who we've added to our team since we've begun is a paralegal who works part-time helping us coordinate our clinics project, and part-time just helps with regular employment unit casework. But besides that, we haven't increased any other attorney time or any other staff time. And the way we've been able to do that is thanks to our partnerships. So in addition to the Temple Law students I mentioned, we also work with community partners who, similar to what Alex was saying, provide space, help spread the word, help run the logistics for the clinics. And we worked with a pretty wide range of community partners, including Community College of Philadelphia, local churches. We've worked a lot with our city council and state representatives, YMCAs, and other community nonprofits. And recently, we've also developed a couple of new partnerships that have been very successful. We've been working with a group called the People's Paper Co-op that integrates art and empowerment into legal clinics. And so they have people from, they also have a reentry think tank of people who have experienced incarceration, who are advocating with the city for policy reform, who come out to our clinics and talk with people who are there to get their records cleared. So by incorporating some of those empowering aspects, I think our clinics have been able to be even more impactful. And we've also begun working with Black Lives Matter Philadelphia, which has been really successful in helping to get the word out, especially on social media and to younger folks, to get them out to our clinics. So those community partnerships have been truly invaluable. And in addition to the law students who are such a huge help at our clinics, our law students actually do all the intake. We have a limited version of Legal Server that they can use to do expungement clinic intakes. They're trained in how to do that. And the reason they're able to do pretty much all the intake with our supervision is thanks to CLS's expungement generator. You may have heard about the expungement generator. My colleague Mike Hollander was the creator of it. And basically it's a program that automates the process of drafting expungement petitions. Pennsylvania, like Iowa, is a state where all of our criminal records information is publicly available online, which is generally terrible for our clients, but in this one instance, it's very helpful because everything's available online, everything can be scraped from the online system and can input into the generator and then produce the expungement petitions. So I'm going to just walk you through a quick demo of how it works. So I'm going to share my screen. Okay, so now hopefully you're able to see my screen. And I'm going to just do a demo using a client who's given me permission to use her name for this purpose. So in the clinics, the law students just go ahead and enter the client information into this form. In the clinics, we'd have them fill out this entire form you see here. For now, for our purposes, I'm just going to click the Start Expunging button. So what the generator is doing now is searching the court record for this client's name and is going to pull all those records back. And look, it happened so fast, it's already here. Basically, then it just shows me the court summary, which in Pennsylvania is our document that shows you all criminal records information. You can pull it up and verify that it's the right client and the right information, the right cases. And then you just click this button again, this expunge button. Now the generator is going to go ahead and draft all our petitions for us. And it even gives us a little summary here of what can happen with each case. So it's programmed to be able to understand Pennsylvania's expungement law rules and even be able to make determinations, which obviously need to be verified, but make determinations about what can happen. So you can see the generator has found one case that can be expunged and one case that can be sealed. So next, you just click on the zip file drive and click Open. And then the zip file opens. It has all the court dockets automatically saved, an overview document that can help you track the case. And here we have our expungement petitions already granted, already drafted, I'm sorry. So I'm just going to show you quickly what it looks like, what the generator was able to put together for us. This is our standard expungement order form. All of the information is inputted from what we put in. It read the records and created this chart of the charges and outcomes. And then we have a petition that has basically all of that same information. So, you know, on the back end, we do have attorneys who have to review these petitions, make sure they're accurate before they're filed with court. But basically, at the clinics themselves, all of this can happen, and it can happen just in a split second while a student is doing the intake. So I'm going to stop sharing my screen now and go back to the slideshow. So thanks to that, it's really been able to streamline our process and allow us to take on so many more clients than we would otherwise, because all of that work's happening. And once the zip files are created with all the petitions, the students just upload that to the client's legal server case files. So then on the back end, all we have to do is click through the legal server case files, quickly review, make sure everything's accurate, and then e-file all the petitions with the court. So the back end work has just been drastically cut down, and the law students are really doing the largest amount of the labor. And we always have a few CLS staff members, paralegals, and attorneys there on site to supervise, but it's made it really possible for us to do this without a lot of additional staff. We also do utilize pro bono attorneys. Sometimes they come to our clinics and help us with those. What's most helpful to us, because we have so many law student volunteers, is actually when we can partner with pro bono attorneys to take cases for clients who are just slightly over income for our services. Sometimes at our clinics we do find clients who are just barely over our income threshold, but still would never be able to afford to hire a private lawyer and pay, upwards of $1,500 for an expungement. So when we do have a partnership with a law firm where we're able to refer those cases for representation because they can take people up to a much higher income threshold than we can. So that's been the most helpful way that we've used pro bono attorneys in our project. So I just want to talk briefly about some of the benefits that we've seen from this clinic model. I mean, the most obvious one that we've talked about a little bit is that we've been able to reach way more people who may not have come to CLS's office for help otherwise. We've also been able to build stronger relationships with law schools and law firms because of it. We actually have an extern who is now in our office every semester helping our paralegal to coordinate all of this work and all of the filings. So we've even been able to build in even more law student support because of the program. We've also really been able to strengthen ties to community partners. We're now inundated with requests from community partners who want to work with us on clinics, and we've set up a little form that they can fill out on our website to request a clinic. But it's really allowed us just to get to know community partners better and really work more collaboratively with them, which has been wonderful. It's also been great for getting local politicians interested and invested in this issue, which is very helpful for future advocacy. And even if you're an LSC organization and you can't directly advocate for legislative reform, inviting local representatives to clinics is a great way to just have them see the huge need and demand for these services, and also see how heartbreaking it is when you have to tell people they can't get an expungement because the laws don't allow it. Just that experience in and of itself can really motivate representatives towards action, and we've seen that happen in our clinics. And the clinics can also be really great for looking at other legal issues and identifying clients who can help with larger advocacy efforts. So our clinics, we keep the scope pretty narrow to expungement, but when other issues do come up in the course of meeting with clients, we have a Know Your Rights table where we can counsel people about their employment rights, and we also will occasionally just take cases on through our normal intake. We won't make the client come back in, but we'll take all their information and assign the case out to an attorney to work on separate from our clinic model when other issues arise. But seeing that quantity of clients and being on the ground in communities really has helped us identify other key issues that are happening and talk to clients about advocacy. So one example that I'll just give quickly is that at one of our expungement clinics, an older woman came in and she had one misdemeanor on her record from decades ago, but unfortunately because it was a misdemeanor of the first degree, under our current expungement and sealing laws, she was not eligible for any relief except to apply for a pardon. And when she learned that, she was really, really devastated, but we were able to talk to her about our current push that I'll talk about in a minute to expand access to sealing to misdemeanors of the first degree in Pennsylvania. And she was so eager to then get involved and help us with advocacy efforts and share her story to help change the law for herself and for other people in her situation. And she's become a wonderful client partner in that work. So that's another benefit that being out in the community can have. But despite all of these efforts and despite the strides we've made, we still know that we're not even close to meeting the need. 50,000 people are arrested in Philadelphia every year, so it's a problem that unfortunately we can never catch up to by filing individual petitions. And so one way to expand our ability to tackle this issue has been collaboration. A lot of groups do really great expungement work in Philadelphia, and the Philadelphia Bar Association took notice of that and decided that they wanted to jump into the expungement space in a very ambitious way and decided to launch a one-day, 6-location citywide expungement clinic that would utilize 200 volunteer pro bono lawyers and paralegals and law students, and would use the generator and just reach as many people as possible in that one day. And partnerships for that day included the City of Philadelphia and the Mayor's Office, the District Attorney's Office, the Bar Association, us, and one of our major law firms in the area. So when they launched this registration on the bar's website, and it was a purely online registration, which at first we didn't know how many people would really register, but within just a couple of days of it opening, over 600 clients had registered, and by the time that they decided to close registration, over 1,800 people had registered. So there was this huge outpouring of clear need for this work. And like I said, almost 200 volunteers were trained to volunteer on the day. Ultimately, about 900 clients ended up being served. The challenge on the back end was that the courts and a lot of the system actors were not really prepared to handle the quantity of petitions that were coming their way. And so the process of really finishing up on the back end of these cases has been ongoing and definitely presented some challenges for the bar leaders who were implementing the project. And we were on board to provide technical assistance and help throughout, but they weren't our cases at CLS. So it was a way for us to try to broaden our impact. But that's not the end of the story in terms of trying to meet this never-ending need, because despite all of the resources in Philadelphia, we know that we're still not catching up to how many people need this help. So the next up on our agenda is Clean Slate legislation, which would use technology to automatically seal arrest records once charges are dropped and automatically seal minor misdemeanor convictions after 10 years. So this automatic technological process would allow the state police system and the court system to automatically use data queries to find cases that are eligible for sealing and implement that without anybody needing to initiate or file a petition. So through doing that on a huge widespread scale, just like this technology has allowed records to become so available, it will now allow those records to not become available any longer, at least as far as the public goes. Law enforcement would still have access to them, and people could still file individual expungement petitions if they wanted to fully destroy the records. So it's here in Pennsylvania, Clean Slate unanimously passed the Senate, and it's now in the House where we're optimistic that at some point it will move forward. And Clean Slate is also a model that's being explored all around the country to help increase access to these services. So I'm just going to end by, again, plugging the Clean Slate Clearinghouse that Chidi introduced at the beginning of the webinar, and say that we do have a listserv of advocates who are doing this work all across the country, and it's a really helpful space to flag questions or to share success stories or share developments in the law. So if you're not already on it and you're interested in being on it, you can email my colleague Janet Ginsberg. Her email address is up on your screen, jginsberg@clsphila.org, and she'll make sure you get added to the listserv. So I think with that, we are now ready for any questions, if there are any more that have come in.
I'm not 100% sure. This is Alex, should I jump in and answer this question about the LSC-funded organizations? Is that fine? Can I talk about that now?
Sure.
Okay, so LSC-funded organizations are absolutely able to do fines and fees and debtors' prison work along with expungement work. There are a few restrictions. First of all, the two most relevant restrictions for those who are in LSC firms, sorry to bore those of you who are not, are doing work that is considered to be criminal in nature, and then also representing people who are currently incarcerated. When it comes to the work that is considered criminal in nature, the definition LSC uses of criminal involves the guilt or innocence of an underlying offense where jail time is a possible penalty. For all the cases that we do work in, whether it's licenses, fines and fees, expungements, what have you, that question has already been determined. It's sort of water under the bridge. We couldn't do anything about it if we wanted to. What we're dealing with largely are issues that are civil in nature that happen after that portion of the case. Also, a lot of case law in Iowa and elsewhere has made a lot of those sort of post-judgment procedures civil in nature, I think largely to peel off things that the right to counsel actually will apply to. And so by doing so, they have come into our world volitionally, and we are here and ready to meet them. The other thing I would say is that any kind of criminal case we could actually do as LSC organizations as long as we used other public non-LSC funds. So if we had a state appropriation, if we had an appropriation from a federal agency that wasn't LSC, anything like that, we could actually do criminal work. Now, the more problematic issue is that representing people who are incarcerated, because that applies to LSC money and any other money we might get, and it's much more difficult to deal with. For those folks, we're really only able to provide advice, some limited action, but we can't participate in litigation on their behalf. So I see a statute of limitations question here, but I'm going to wait until I'm cleared to answer that because there may be other folks who want to answer other questions. But one more thing about the LSC thing, actually, real quick before I go. There's a NLADA, the National Association of Legal Aid and Defender, the National Legal Aid and Defender Association. They do some counseling and compliance counseling on LSC regulations for LSC-funded programs, and they have put together an excellent memo that analyzes legal opinions by LSC going back decades to put together a very clear set of rules and guidelines that LSC programs can use to engage in a wide variety of collateral consequences-related issues.
Jamie or Beth, do you guys have any questions you want to answer?
Getting some weird feedback here. Anybody else having weird feedback? Or is that just, okay, now it's better. Okay, I see one question here that's about once records are cleared, can you no longer put it on an employment application if it's asked about? That's actually a very good but also very complicated question that varies a lot state to state. In Pennsylvania, a quirk of our laws is that if you're getting your records sealed, there is a very specific provision in the sealing law that says you no longer need to disclose it on employment applications. Unfortunately, we don't have that same provision in our expungement statute. So often we'll advise clients, first of all, we have a ban the box law in Philadelphia, so that question shouldn't even be on applications to begin with. But we always advise clients, if they're illegally asked about their record when they shouldn't be, they should still be honest and answer truthfully if they have had an arrest record, but then you know, explain that it's been expunged or sealed. And then if they end up being denied the job, they would have a much stronger case against the employer because it's clear that the employer was using illegal questions and information against them. Whereas if they just withheld information, the employer might try to claim they weren't denying them because of the record, but rather because they weren't fully honest. So it's a little bit of a tricky situation where the laws and real world don't really collide perfectly. But that's generally the advice that we give clients here in Pennsylvania. I'm sure there are other states that have much clearer laws where lawyers might feel more confident in telling clients that they don't need to disclose anymore, but I'd be curious, I don't know if Alex or Beth have answers from their jurisdictions about that issue.
Sorry, I muted myself. No, I mean, I think it's different in Illinois for two reasons, in the fact that we have a Human Rights Act that prohibits employment discrimination based on expunged or sealed records and prohibits employers from asking about expunged or sealed records, requiring specific language on applications prior to our statewide ban the box laws. While there's no direct answer, I know some states explicitly say you can say no to that question. That is not so clear in Illinois, but we do advise our clients to do that because of the extra protections that are embedded within our state laws.
This is Alex. I'll talk about it a little bit from the Iowa perspective. You know, we don't have ban the box. It's something the legislature has considered a few times but never passed anything. We actually have an issue that sort of goes beyond sort of the level 0. If ban the box is level 1, we're at level 0 in that our Department of Criminal Investigations currently has a process by which in Iowa, if you expunge something, the legal effect of that is to make it confidential. The case still exists in a database, a secure database. It can't be accessed by the public, but it still exists. There is a process that our Department of Criminal Investigations uses to allow employers to get a waiver of that confidentiality from prospective applicants, and then they can receive information about expunged cases just as if it were public record, which is it defeats the purpose of a lot of the expungement law, and it's actually a terrible, terrible waiver process. You would have no idea if you were even an attorney exactly what you were waiving based on the way the form is put together. Plus, it's overbroad. A lot of times what you hear from employers is, well, there are certain federal requirements for, say, working in an FDIC-insured institution where you have to ask about cases expunged or no. And to the extent that's true, which I don't 100% concede that what they have to do is then, actually disclose this stuff. But to the extent that it would even be true, the current process, in addition to being a completely, non-informative waiver of very critical rights, also is not limited to the sorts of things that any particular employer might say they are required to get. For example, FDIC requires, disclosure of issues related to financial crime or theft. You have a drug conviction. That's not something that the FDIC would technically, be able to require you to disclose, even if they can require you to disclose anything. And so, those processes should be limited. So I guess the short answer of all this stuff that I just spit out is we've identified some bad practices that we think there are some advocacy routes to fixing.
Thanks. I see another good question that perhaps we can all weigh in on from our colleague Brenda in Georgia. It says, could you talk more about the training you provide for volunteer attorneys in Georgia? Sealing is discretionary, so there is a good possibility there will be a hearing, and non-criminal attorneys can be wary. How in-depth is your training? So for us at CLS, most of the cases we're taking from our clinics, while volunteer attorneys might help with the intakes, are coming in-house, and so if there are objections to those cases, it's also discretionary in Pennsylvania. Our attorneys on staff are most likely to be the ones in court representing on those cases. Sometimes we have certified law students who we train and are able to help us with that. But for the cases we refer to a private firm to handle, as well as when we worked with the Philadelphia Bar to do that huge-scale expungement clinic process, we provided a bunch of training. So we first did a training on the front end about just what's eligible for expungement, how the process works, how to file, that kind of thing. And then before the hearings came up for those that were being objected to by the district attorney's office, we did another training that was specifically about court practice and some of the case law and how arguments go to give more practical tips. But on top of that, I would say it was still pretty challenging for the attorneys who felt like they didn't really have a lot of knowledge and experience in the area. We gave them like training manuals and as much support as we could. But we also tried when possible when we knew they were going to have days where they were doing a huge bunch of hearings from the private volunteers, to have one of our staff there present if possible to answer questions and troubleshoot. And by doing that, we found that there were a lot of questions to troubleshoot in court, and it was really good that we had somebody there with more expertise. So I think that's a really great question, and I don't think there's a simple answer if you're actually using volunteers to do the courtroom arguing. I think the more hands-on training and technical assistance you can provide, the better outcomes for the clients. But I think sometimes because of that trade-off, it is easier in some ways to have your own staff who are experts in this area do those hearings. So it's just a question, I think, of balancing resources and the scale and scope of what you're trying to do. But I don't know if Beth and Alex also work with any private lawyers who take these cases to court and have any perspectives they want to add.
Yeah, so Brenda, I wasn't sure if you're asking about training for pro bono overall or just in the courtroom activities. For contested petitions to expunge and seal, that's a graduated volunteer opportunity for folks. We typically offer it to individuals that have been on the front lines doing the record research, doing the consultations, the document preparation through our help desks or summits. In terms of courtroom litigation and other aspects for us would be certificates of good conduct. We typically have a 2-hour training that talks about all aspects, but an attorney here is always assigned to a case. It's typically done by our pro bono coordinator, our lead attorney in that project, where they're never out there on their own. And when individuals volunteer at our court call at 26th Street, they are always supervised by one of our volunteers. So our goal is to provide continued support, not just on the front end of training, but throughout the actual course of representation, which seems to be of benefit both to the clients and to the volunteers.
This is Alex. I'll just be really quick. We generally use our pro bono resources for things other than court representation, just about everything else, so that we can free up as much of our, specifically Rob's time, for that extended representation. And so the training is not as difficult, obviously, because we're not sending people into court. Plus, the day of the clinic, especially for the first few cases people get, you know, we're kind of almost shadowing them the entire time, kind of popping in and out, and making sure they feel like they have enough support. We hope to, at some point in the future, get some of the clinic attorneys to take some of these on, but that's kind of a next year thing.
Great. And I see another question here. In any of your jurisdictions, do clients receive notification of eligibility for expungement via the court or probation? In Philadelphia, the answer is a resounding no to that, and in fact, many of our clients don't even realize that non-conviction arrest records stay on their record even after the case is dropped. So lack of knowledge about eligibility or need for expungement services is certainly a big problem. That's part of the impetus behind the Clean Slate push, is to just make this happen automatically so that people don't need to, you know, have this specialized knowledge of how the system works to be able to receive these services. We have had discussions about, with the Clean Slate legislation, what kind of, assuming it someday passes and is implemented, what kind of public education campaign we might need to undertake to let people know that that is happening and they're receiving this benefit. So I think that's a great question. I think some jurisdictions might have those notifications. I don't know if Illinois or Iowa do.
In Illinois, there's the law and there's reality. So the law states that judges are supposed to advise people about their ceiling eligibility. You never see that. Most judges don't even know ceiling eligibility. And we recently had a change in our admonishment statute that also requires individuals to be admonished as to the collateral consequences of a conviction, which requires defense attorneys to be providing that counsel up front. In all practicality, as any of us know, those barriers are so nuanced, and even as someone that does this work all the time, we don't know all those. And I think it's an unfair burden to put onto, you know, the courts. But it is what the law says. Is it happening in reality? No.
This is Rob in Iowa. We have a few different mechanisms for record clearance. So with juvenile sealing, the General Assembly enacted a law 3 years ago that requires courts to automatically set a hearing. So not only are people notified, but the court sets a hearing to determine whether the charge is eligible for juvenile sealing. With dismissal acquittal expungement, I have seen a few courts that put in the disposition order that a charge may be eligible for expungement at some time in the future, and what the requirements are under our dismissal acquittal expungement code, but that, like Illinois, by no means is that standardized, and in Iowa, unlike Illinois, it's not even suggested by law, so it's just a few courts are doing that. With respect to deferred judgment expungement, so somebody who pleads guilty but their case is deferred and they complete probation, pay all their costs, and then you know, under Iowa law can be expunged, that's supposed to be an automatic process, but through the expungement clinics we've found several cases, including one where we called the clerk after figuring out that a deferred judgment case should have been expunged. The clerk, the client had been unsuccessful in convincing the clerk that the case was eligible for expungement. The clerk opened the file, said, whoops, this was supposed to be expunged, and then went and expunged it. So that was one of our more successful stories.
So I think we've gotten to most of the questions either by writing notes or addressing them. I just wanted to put up this slide that has the contact information for Beth, Alex, and myself, so that if additional questions come up as you're either thinking about doing more of this work or thinking differently about how you do this work, you can feel free to reach out to any of us with questions. I also wanted to note that at CLS we've been working on developing what we've called a clinic in a box, which is basically just a guide to how to think about some of these issues and start your own records clearing clinic practice. And it includes some of our sample forms and resource packets that we give out at clinics. And that's going to be circulated to participants at the end of the webinar as well. So there are a lot of resources for following up if you have additional thoughts or questions. I don't know if there's anything else that anybody wants to add or share before we close out.
Well, if not, I just want to take this opportunity, this is Chidi Umez, to thank all the presenters today and to encourage everyone to please go on to cleanslateclearinghouse.org for this webinar and other webinars and trainings relating to record clearance. And as Jamie said, more of those resources that have been talked about will be provided on the site as well. And to sign up, also encourage everyone to sign up for the newsletter to receive more information on news, events, and webinars such as this one. And with that, I just want to thank everyone again for joining us today. Have a good afternoon. Thank you.
Thank you.